So the enforcement branch, so basically it's the enforcement branch of the compliance committee that's in charge of looking at the end on whether the targets have been met, and I'll give you a case of that later. It also looks at whether the party has met the key methodological and reporting requirements. The first question, has the report been submitted on time? And if it's been submitted on time, does it meet the quality standards that are set out in the relevant requirements? And then if it determines that there's non-compliance, it then applies consequences. And what are some of these consequences? The first one is a declaration of non-compliance. A typical decision of the enforcement branch starts with the declaration that the party is in non-compliance with this or that standard. So that's the first sentence. And then, after having determined what the non-compliance is about, then usually the enforcement branch will require a party to submit a compliance action plan within 3 to 6 months, depending on circumstances, where the party analyzes the reasons for the non-compliance and how it then proposes to come back into compliance. And this is actually a difficult area for the enforcement branch to agree on, because this assumes when you're asking a party to prepare a compliance action plan that you as a compliance committee yourself have pinpointed exactly what the problem is. Because if you want the party to give you a compliance action plan that helps you then as a compliance committee determine whether they're back in compliance, then you have to provide the party with the proper guidelines. And it's not that easy. There have been very long debates on exactly what do you want to get back from the party. And then in some cases, the branch has suspended eligibility. So we talked about flexible mechanisms. So there have been cases where one of the consequences applied was actual suspension of the right to trade in those units. And considering that most of the parties that have come before the compliance committee are those which we call in climate change, the economies in transition, so the ones with surplus units, to actually suspend their rights for a year or 18 months can actually hurt economically. And we've seen that parties saying we're losing millions because we had contracts, we were supposed to sell units, but because you've suspended our rights, then we have lost those contracts, and some of them even say they're being sued because they couldn't deliver on contracts. And then if a finding in the end is made that the target has not been met, then the difference between the target that was supposed to be met and the actual emissions, you take that figure, you add 30% to that, and you basically then, as a compliance committee, would say that the next target for the next compliance period becomes more onerous because you add those units that you've calculated as a penalty. Now, with the facilitative branch, it was supposed to be the more promising and most active branch of the compliance committee, because it was supposed to be the one that would provide advice and facilitation, especially during the beginning of the commitment period. And then it was supposed to give early warning to a party if it seemed like a party was not going to meet its target. So that was the theory. And then what it had before, the means that the facilitative branch had before it was to give advice, to give financial and technical assistance, advice and facilitation, and to make recommendations to parties. But in fact, and we can speculate on why this is the case, facilitation was not really used very much in the compliance system. So, but let's review some interesting cases. Okay. So we said that there have been no cases before the facilitative branch. Well, there was this one, and here is an interesting case. South Africa, which was chair of the Group of 77 in China, a very big negotiating bloc of more than 130 countries, made a submission to the compliance committee. I think this was in 2006, so the first year of operation of the Compliance Committee. And it listed 15 parties which it claimed had not submitted a certain report on time. Okay. The facilitative branch could not decide what to do with this case. Now we backtrack. The timing, when was this? The climate convention had just had one conference. It was a particularly contentious conference in May. And that's the time when parties get together. And then a few days after that conference was over, this submission was received. So you can theorize about whether it was a fallout of the negotiations. But this was the first potentially party-to-party trigger. But what happened was, this was a time when the Compliance Committee was still negotiating its rules of procedure. So the members of the Facilitative Branch, to which this case was assigned, had different evaluation of the submission. Some said, no, it is not a valid submission because G77 and China did not authorize South Africa to submit this. Some said, but there's nothing in the rules that say that one party cannot submit on behalf of others. And then some others also, the interesting thing in terms of the obligation here was the report that G77 and China through South Africa was claiming was not submitted was something called a report on demonstrating progress. And the interesting thing was that the Kyoto Protocol did say that the Annex I parties should demonstrate progress in achieving their commitment. So the substantive obligation to demonstrate progress was in the Kyoto Protocol, but there was no reporting obligation under the decisions adopted by the CMP, so the highest decision-making body of the Kyoto Protocol. The reporting obligation to demonstrate progress was in a COP decision. So, and the COP is not the governing body of the Kyoto Protocol. So there was also an ideological debate in the committee. You say, if there's substantive obligation exists in the protocol, but you don't have the decision to implement that, can you argue that this was a valid reporting obligation? So lots of debates, but in the end, no decision could be taken. And just to give you an insight, normally when the Compliance Committee looks at a case, it decides in principle whether it will go one way or another way, and then it works out the text of the decision. In this case, since there were no rules of procedure yet, and this was the first case that the committee had received, they were unclear on how to go. So they couldn't even decide what the in-principle decision was. And so what they did was, one group prepared one kind of decision, so to proceed. Another group prepared another kind of decision, not to proceed. And the Compliance Committee has very high voting majorities. So they voted on this decision and on that decision, and neither decision got the majority required. So in the end, actually, technically speaking, they couldn't decide, but the default then was that they couldn't proceed on the consideration of the case. So the first party-to-party trigger did not proceed.